Uh, Good afternoon, everybody. My name is Sean Benoit. I'm an attorney with the Community Health Law Project, and I'm here today to talk about school-based transition services and supported decision-making. So basically, I'm going to talk about for use with disabilities that are going into young adulthood. I'm going to talk about what types of transitional services you can get through school districts, through special education, as well as other things that are out there for youth transitioning into adulthood in terms of housing, Medicaid, things like that, as well as what sort of supported decision-making options are out there between supported decision-making, power of attorneys, and then the most restrictive form of decision-making, guardianship. So I'm going to go through all that. So just to start with, the Community Health Law Project, we are a nonprofit organization that provides legal and advocacy services to residents of New Jersey with disabilities. We serve consumers who are receiving mental health services, people with physical disabilities, developmental disabilities, as well as visual and hearing impairments. And we represent in a wide variety of matters, public benefits, Social Security, welfare, food stamps, other entitlements. We do housing issues, landlord-tenant disputes, some foreclosure work, some guardianship work. We do different kinds of legal documentation prep, special ed, consumer protection, Medicaid cases. We do a whole variety of stuff. We kind of have, the Community Health Law Project has what we consider to be a holistic needs approach. We look to what issues the clients may be having outside of what they originally came for. For example, a client comes to us with a landlord-tenant matter, but their health needs aren't being addressed. Their private duty nursing has been reduced, or their PCA has been denied, things like that. And we try to address as many of the issues or problems that the client is having, so that we can help as best we can. We have several regional offices throughout the state. Our admin office is in South Orange. We have a North Jersey office, East Jersey, Shore area. Basically, we try to service all of New Jersey. We even have a few satellite offices that are not on here. We have one in Jersey City, one in Neptune, and I think there's one other. But anyway, these are our main offices and our phone numbers to refer folks to. So like I said, one of the things I want to talk about is what transitional services are available to folks through the special education process. So one of the things I'm just going to do very quickly, I just want to give a very, very, very brief overview of special education, and then I'm going to delve into transitional services that special education students are entitled to. But I do want to make sure that everybody listening in is on the same page with me as far as special ed and what schools are required to do. So special education comes from the IDEA, and that is the Individuals with Disabilities Education Act. It's a federal law, and then there are state regulations and statutes that implement that federal law here within New Jersey. And when we talk about special education, we talk about specially designed instruction. It's unique to the child at no cost to the family, and it's instruction in the classroom, at home, in hospitals, institutions, detention. It's wherever the child is. When we say at home, typically we're referring more so to if the child's not able to go to school. But even if the child is in school, there could be services within the home. Schools oftentimes like to draw kind of a bright line, school versus home. But if you can show a correlation between what's going on at home versus what's going on in school, school district may have to provide services in the home. I always, as an example, use school avoidance kind of cases. As to something where the school should be looking to services in the home to help get the student to help figure out what's going on and try to get the student into the classroom. Special education instruction is not just, it's not limited to academics. There's physical education, social skills, behavioral modification, and there's also vocational education, those transition services, which we're going to get to in a minute. And it's specially designed instruction, and it has to be, adapted content, methodology. It has to be unique to the student. A student is eligible for special education if they are a child with a disability and the disability adversely impacts their ability to learn in the classroom. And that disability could be physical, emotional, learning, cognitive, and it's ages 3 through 21. Prior to age 3, children can receive early intervention services, and if they have a disability starting at age 3, they could be eligible for the for school districts preschool with the preschool disability programs. Once you turn 21, you are eligible for services through the end of June following your 21st birthday. So, for example, if you turn 21 on January 1st, you can continue going to school until June 30th. One thing I want to bring up, because we are going through, a pandemic, we're still, we still are in the midst of it. Due to the COVID-19 pandemic, as I'm sure everyone is aware, schools were closed for a period of time, remote virtual learning from March 2020 through June 2021. So back over the summer, the New Jersey legislature put a bill into effect, and it was signed into law by the governor. And it addresses students that were aging out and an extension of the age limit for special education. So for any student that would have been aging out, so, June of the 21st birthday, any student that would have been aging out last school year, this school year, and next school year, they could be eligible for an additional year of schooling. This is a good thing. It's not an automatic guarantee that they're going to get that additional year. What you have to do, if you have a child that's aging out, or you're working with a client that's aging out, you have to contact the school's child study team, the case manager, request an IEP meeting, and they have to determine the need. Because if they're denied that extra year, the parent or the student would have to file for due process to challenge that. I could spend 3 or 4 hours talking about due process easily, but that would be a different presentation. But if you do have a student that you're working with, or a family member that is aging out, ask for the IEP meeting. What you want to look at is you want to look at what was missed during the time that school was entirely virtual. For example, I had a client for the pretty much all the 2020-2021 school year could not do any of the community-based programming in the IEP, specifically job coaching and job sampling. The school district had a really great job sampling program set up, but all the job sites were closed due to the pandemic. So that's a good example of a student that would need to continue on for that additional year, because there was so much that she had missed out on. Again, just kind of the basics of special education. There are 2 main tenets to special education: Fape and LRE. Fape is a free, appropriate public education. That means that the school district has to provide something that gives the student the opportunity for meaningful, significant progress. And that's important, because that Fape standard applies to transitional services, which we're going to get to. I keep saying in a minute, but we will get to it in a minute. So that is Fape. Again, that's one of the cornerstones of the idea of special education, an appropriate public education. An LRE, least restrictive environment. Under the IDEA, you have to make whatever attempts to have a special education student in the least restrictive environment, with in the least restrictive classroom setting within the school district. So this is more about LRE here. So now we're going to jump into transition services and transition planning. Starting at around age 14, when the student starts going for their yearly annual IEP meetings, the school district should start talking about transitional services, identifying post-secondary goals. By age 16, there needs to be a statement of transition planning within the IEP. Basically, like I said, you want to identify what those post-secondary goals are and develop a course of action. Is the post-high school goal going to be entering the workforce? Is it going to be college? Is it going to be, for some students, it might be acquiring life skills, independent living skills, so that the person is able to live out in the community on their own. And those, whatever the goal is that you identify, it's unique to the student, and the way you get the student to that point is going to be unique to them. So you do need to have that set transition planning within the IEP. And again, at around age 14, it should be starting. By age 16, it should be solidified. And you can continue to receive transition services even if academic requirements have been met. At age 18, the school district could say, okay, it's time to graduate because you have all the credits. You've done all your ELA classes, all your math classes. You have the credits to graduate. But the student can still stay in school. They don't have to graduate if they are still in need of services. Examples: job skills training, coaching, vocational training, life skills. So merely completing those academic requirements, getting the credits, does not mean that the student has to graduate. There's still more that may need to be done. So transition services are a coordinated set of activities. It's designed to be results oriented, focused on improving academic and functional achievement based on the individual child's needs, as any special education service should be. And it should include instruction, related services, community experiences, development of employment, and other post-school adult living objectives, and when appropriate, acquisition of daily living skills. It's important to note that I had some cases years ago where you look at the transition planning and it says post high school goal is to enter the workforce. So it's, how do we do that? Referral to DVRS. Now, DVRS is a great agency. I'm not knocking DVRS or anything like that, but that's not necessarily an appropriate transition plan for a school. You definitely want to have other organizations, other agencies involved in the transition planning, because there's so many great services out there. But a mere referral to an agency does not constitute FAPE. It does not constitute a free appropriate public education. So again, the statement of transition planning, you are going to find it in the IEP, and you want to make sure that it's written well. Like I said, merely having a referral in there is not enough. You want everything to be laid out. I've done a lot of special education trainings over the years. One of the things I always like to tell families about an IEP is, think of the IEP as a contract, a binding contract between the family, student, and the school district. And like any contract, if the terms of it are not being met, you can go to court and have it enforced. With the IEP, it's actually a little bit easier, because you might not necessarily even have to go to court. You could file with the Department of Education, the New Jersey Office of Special Education Programs within the Department of Ed for enforcement. You could file a complaint investigation. Ultimately, those don't resolve. You file for due process, you get in front of a judge. But there are ways to enforce provisions in an IEP without necessarily having to take the route of due process and going in front of a judge. But again, that's only if it's very clearly laid out in the IEP. So again, starting at age 14, you should be talking about these things with the child study team. By age 16, you want to have things in writing so that you know what the plan is and how that plan is going to be achieved. I kind of alluded to this a little bit, but for example, if the plan is to enter the workforce, how is that going to happen? You want the summary of programs and related services that are needed to achieve that, and you want it in as much detail as possible. Is it going to be vocational school, a vocational program? Are you going to, if the local high school does not have that vocational program, are you going to go off-site somewhere? Is it specific classes? If somebody's interested in, becoming a mechanic, an automotive repair, again, that would be something more vocational in nature, and they have classes where that can be taught. Does the school have a program offering job sampling and job coaching? For some kids, for some people transitioning, again, everybody's needs are different. Cognitive functioning might be a little bit lower, so they might not be sure of what they want or what they're able to do. So, you're going to look at a program that would have job sampling and job coaching. If the school doesn't have an in-district program with that, do you make that leap to out of district to look for something? And again, it all depends on the student's needs and whether or not the school district can provide FAPE. So I have a note here saying COVID-19 related issues. I already mentioned that. I use that example I have with that one client, just because we are living in a pandemic. Last year was tough. I haven't done that much this year, so I'm not sure what students and schools are dealing with this year with the job sites. I think things have been opening up, but I'm not sure, if the developed job sites that the school districts have with, community partners. I'm not sure what the status of those things are. So it is something to kind of be mindful of. Like I said earlier, I always use this as the example. Does IEP just say referral to DVRS and nothing else? There was a case I had researched years ago, and it basically said that for that specific student, a referral to DVRS was not appropriate, and it was a denial of FAPE. A denial of FAPE, if you go to court and you can prove the school district denied the student FAPE, you're going to be able to get services in place. You know, and again, other agencies can be involved, and families should be reaching out to them if they hadn't, to see if they're you know, if their family members are eligible. There's DDD, the New Jersey Division of Developmental Disabilities, DVRS, the Division of Vocational Rehabilitation Services, CBVI, the Commission for the Blind and Visually Impaired, DMOS, Division of Medical Health and Addiction Services. I always get DMOS confused, but these are agencies that could also provide programs and transitional services. So definitely having other agencies involved throughout the process it can certainly help. So again, with the statement of transition planning, you want to look to what is the goal. Is the goal independent living? You know, what program is being offered? Are they teaching life skills, functional academics? You know, is this a student that's going to need to learn how to pay for things at a store? You know, I say balance a checkbook. I don't know if anybody physically balances a checkbook anymore, but I mean, like getting, you know, being able to log in online at the account, see where the expenses are, and log what you're spending. You know, functional academics, you know, can do that, because it will take, you know, basic, it will take math and apply it to real world situations that you would need if living out in the community on your own. I do want to bring up evaluations, because there is a great evaluation that can be done when you're in the midst of transition planning. And I don't know, you know, I think it was a few years into my career doing special education litigation before I really kind of had requested an FVA for a client, because it wasn't something that came up that often. So I always like to talk about these, because not everybody's always aware of them. So when you have a student who is a special education student, there are periodic evaluations that do have to be done of the student. Most school districts refer to them as the triennials. At a bare minimum, once every 3 years, a school district does have to do a comprehensive set of evaluations to make sure that the student remains eligible for special education services. Psychological evaluation, learning, psychiatric, functional behavioral assessment, an OT eval, PT, speech. For any parents with a child, you know, special education services, you're probably familiar with a lot of those terms. There is an evaluation called a functional vocational assessment. And what a functional vocational assessment does is it tests the students, and it can give recommendation as to what that kind of post-secondary should be, and possibly how to achieve it. The functional vocational assessment is going to look at the students' cognitive skills, their motor skills, their perception, learning preferences, you know, career awareness, development, their knowledge of jobs, their strengths, you know, what they want to do. And they're going to try and do a whole, you know, skills assessment of their needs, of their skills, and try to come up with ideas as to how to get to that point. There was a place down in South Jersey that used to do these really great functional vocational assessments. If I remember correctly, it would take like two or three full days. In their facility, they had like these hands-on workshops where the student could go in and actually try different things, and they could see what the student was interested in, what their, you know, kind of what their strengths were, where they were, where their skill set was, and they really put together some really comprehensive reports with you know, with a lot of good solid recommendations. I've also had school districts where we've requested, which, by the way, I've often been told that that when I'm doing a training like this and I talk about school districts, I come across as very negative towards school districts, or like I'm bashing them, and that's never ever my intent. There have been some truly great school districts that have done a lot of good work with students. You know, when I did a lot of special education litigation, unfortunately, the cases I took were, you know, cases where the schools didn't do the right thing. But, you know, there's 600 some odd school districts in New Jersey, 800 if you include charter schools in that. So there are a lot of school districts that do the right thing and are, they're doing the right thing. Since I've had the experiences I have, I try to, raise this awareness. So if something's not going the way it is, the family or caseworker, somebody working with the child, they know what to look at. So one of the experiences I had, we had asked for the functional vocational assessment, and they said, "Oh, we'll do a skills assessment as part of the psychological evaluation." And that's not appropriate. That's not a functional vocational assessment, and shouldn't replace that. I remember in that case, the skills assessment, it was helpful, but it was it was a self-reporting, I think it was like a 3 or 4 page fill in the blank test that was administered to the student. And that's not a functional vocational assessment. So I wanted to make sure to talk about that. I'm going to step outside of special education for just 1 second, then we'll delve back into it. There are other, like I said earlier, getting other agencies and programs involved is a good idea, because there are other programs out there, and I'm still learning about some. A decade into my career doing this work, I'm still learning some as I go along. The New Jersey Department of Labor has the Workforce Initiative and Opportunity Act. They have a youth services program, and it does provide services to youths age 14 to 24 who face barriers to employment. And this is run through the New Jersey Department of Labor's one-stop career centers. And this is not something you have to be a special education student to access. But again, it could be something that could be helpful for some of our clientele. So it's just something that's good to know about. Another one, the center, New Jersey has these centers for independent living. They are community-based, consumer-driven organizations. They provide informational referrals, peer counseling, skills training, advocacy, other services that are based on individual needs. This is a service that is run through, funded by DVRS and DOL, the Department of Labor. And I have a link here to the state website that has the list of the Centers for Independent Living in the state. So now I'll jump back into special education for a second. So we talked about transition services and getting services between the ages of 18 to 21. Something else that a special education student is entitled to is related services. And those are services that a student could that could assist the student in benefiting from special education. And it's determined by the IEP team. And these are things like transportation, counseling, social skills instruction, OT, PT, speech. These things do not end at age 18. If the student is still receiving special education services in that 18 to 21 range, they absolutely can still be getting related services, PT, social skills training, all of that. So, and those are things, again, that can help transition into adulthood. There are, again, talking about other agencies, there are other transitional services that are out there, for people that are eligible for DDD, the Division of Developmental Disability Services. There are day programs that are available to young adults after they have aged out of school. The day programs are independent providers, they're private, they're nonprofit, et cetera. And DDD will fund it if the person is eligible, and they'll get a budget for those things. So definitely exploring DDD eligibility, while the student is young, is a good idea. So basically that kind of wraps up what I wanted to say about special education. It looks like we have a question. We're doing pretty good on time, so I'll let me see what the question is. Can a youth who is high functioning, participates in AP classes, still get work study to go out into the workplace while in this program? Can the school deny youth from the work program you mentioned earlier? Get denied youth from the work program. I'm not sure which work program you mean. If you're talking about the work initiative through the Department of Labor, or if you're talking about the community work placements if you're talking about the community work placements that the school district will set up, as far as like job sampling and job coaching, for a youth that's higher function in AP classes, if their goal is college afterwards, they're probably not going to be in the type of program that would have the job coaching and the job sampling. So it's not that they would be denied. It's not something that they would really, that would be appropriate to them. How does due process work if you move to a new district? Can you still sue the former district for not delivering on the youth's needs after moving or while trying to? Yes. So that is possible. What would happen is if you move out of that district, there's a 2-year statute of limitations. Excuse me. There's a 2-year statute of limitations in regards to special education Fape denials. So if you move into a new district and you believe the previous district did not provide what they were supposed to provide, you can file suit and you can go after them. It would have to, but what you'd wind up getting is something called compad. There's a case, I want to say it's DSV Collingswood. It's been a while since I had to reference it. It probably about 15 years ago. It was either New Jersey District or Third Circuit case, and basically it was a student who moved out of state and then went back against the old district, and the district tried to claim that because he was outside the district, outside their jurisdiction, they couldn't provide services. Therefore, the claim was moot, and the court said no, because you could provide comp ed. You could set up a fund, a trust fund, put money into it, and then the student can get services for themselves wherever they've moved to. So absolutely, you can go after the old district. As far as the name of the agency, I don't like to make specific recommendations. I'm not sure if it's appropriate during a presentation like this, but that said, I actually can't remember for the life of me. My email is at the end. If you want to email me, I can dig back through my old notes during the week, and I can certainly send you the contact information. Alrighty. Okay, so that pretty much wraps up as far as special education. What I'm going to kind of delve into now is other types of services that are available for youth as they start to transition out. Oopsie. Oh, there we go. Okay. So obviously as a young adult, teen becoming a young adult, healthcare is always something that is important. Medicaid is so in terms of Medicaid, if you do have a young adult, that family member, again, somebody that you're working with, they could be eligible for Medicaid. So in New Jersey, there are a couple different types of Medicaid. If you go to New Jersey Family Care's website, you can Google New Jersey Family Care. You can see the different Medicaid programs that are out there and see whether or not the person will be eligible. One of the ones that I've worked with more with clients is the ABD program, the Aged, Blind, and Disabled Medicaid program. It's for people over 65 or people with disabilities as determined by SSA or DMOS. There are income and asset limits. I've worked with a lot of clients who are receiving SSI, supplemental security income. If somebody is receiving SSI, there's a good chance they should be able to be eligible for the ABD program. I think the asset limit is like 2,000, same as it is with like SSI. So Medicaid will usually do a 5-year look back to last for bank statements, things like that. There's New Jersey Workability Medicaid. So if somebody has a disability and they are working, they could still be eligible for Medicaid to assist with healthcare. I'm not as familiar with that program, but again, if you go to New Jersey Family Care, you can their website, you can get a lot of this information off of there to see if the family member or person you're working with would meet eligibility requirement and could get Medicaid. Housing is obviously a big one. Where are people going to live? And in New Jersey, we have a lot of different options. Some are easier than others to get. Nothing is really truly easy. There's a lot of wait lists. But again, if you're planning long-term, it is something to start thinking about. If your family member or client that you're working with is DDD eligible, there are obviously group homes, things like that you can look into. But outside of that, there is affordable housing. Affordable housing is not the same as public housing or subsidized housing, which I'll get to in a second, but you'll see like a lot of the new buildings going up throughout towns. They have affordable set-asides with income restrictions, and they have their own application process. You have to look for those individually and apply to see if you can get in. There is public housing, the PHAs, the public housing authorities. Not every town or city has one, but the majority of the bigger cities and towns have them. I operate out of Union County, so like Rahway has a housing authority, Elizabeth, Plainfield, Linden. So they have housing that is set aside. There's income restrictions, and you can apply to the individual township or city housing authority. They can try and get on their wait list. We can see if they have any immediate openings. I know as of right now, I don't believe any of the housing authorities, at least in the area that I work in, have immediate openings. Everything seems to have wait lists. Then there's other types of subsidized housing. There's vouchers. There's Section 8 vouchers. There's like SRAP vouchers. There's all different kinds of housing vouchers that could be available. You can apply for these vouchers. Some of the public housing authorities administer like the Section 8 vouchers and things like that, and you can apply for them through it. DCA, that's the New Jersey Department of Community Affairs. They administer federal and state vouchers as well. If you're working with, with certain groups, like I know Bridgeway is they're a great organization that we work with up here. Actually, it's funny. I think in one of the questions I said I didn't feel comfortable naming agency, and I just did. But there you can, with these different agencies you work with, some of them have access to housing vouchers, depending on the person's disability, and they may be able to try to get them in. Some are permanent vouchers that, as long as you meet the criteria, you can remain eligible for, indefinitely. Some are emergency vouchers that might be good for 12 months or 24 months. It just kind of depends. There's also EA, emergency assistance. If somebody is receiving GA, the welfare general assistance, or a family on TANF, or if the person is receiving SSI, they could be eligible for housing through EA. You would contact your county social services, and what they would do is, again, they would make sure you're eligible. They could do temporary shelter hotel placements if the person is facing homelessness. And they also do have some temporary housing vouchers. I think that's where you would get an SRAP voucher from, but don't quote me on that. But EA is an option. And then just to mention this, I'm sure most folks know, but there is COVID rent relief through DCA. If you do have anybody that is experiencing or going to be experiencing homelessness issues due to the COVID pandemic, they weren't able to work, they didn't have money to pay rent. Google Department of Community Affairs, DCA, New Jersey DCA, COVID rent relief, and there's a lot of information out there about how to apply for funds and get funds. And again, and for those folks that are not able to fully live on their own, which, by the way, let me back up a second. Public housing, Section 8. You could get PC. I say not able to live on their own. Folks that are not fully able to live on their own could still live in those environments. You could get services through Medicaid. You could get PCA, personal care assistance, if you need some help with ADLs in order to stay, in order to be out in the community. If you need PDN, if you need a nurse coming out, there are services out there to be able to live in the community in those types of housing situations. For folks that maybe have more needs where that cannot be met in that type of a situation, the DDD, if you're DDD eligible, there are group homes. The New Jersey, the state has what is called the New Jersey Housing Resource Center, and they can assist with finding affordable housing, both rental and sales. And I have their website linked here. If anybody needs a copy of the slides, again, my email will be at the end. You can write it down, email me, and I can certainly send you a copy of the slides if you need any of the information in here. All right, so those are the kinds of services that I just wanted to kind of touch upon as somebody segues into adulthood, coming, leaving school and things like that. For somebody with a disability, depending on how the disability impacts them, they may have they may need assistance in making decisions. So when we talk about Sarika decision making, and I think there actually might have been some trainings earlier in the day or yesterday in regards to some of this. So if I'm repeating anything, I do apologize. So when we talk about assisted decision making, there's non-judicial and then there's judicial. Obviously, non-judicial is the least restrictive, and we're going to go through them kind of in order of least restrictive to more restrictive. And then there's the most restrictive, the judicial one, where you do go for guardianship. Working in the disability rights community for a number of years, guardianship, it is something that can be tough to kind of talk about at times, because it does strip away a person's ability and rights to make a decision. And once guardianship is granted, to undo it can be difficult. And it is not something. I am somebody that does think that there are times where it is necessary, but I do want to see the other forms tried before reaching that. But I'm going to go through all of it just so folks have the information, so that so that people can make an informed decision about what's best for them, their family, or the clients that they work with. So non-judicial, we talk about supported decision making. Again, this is the least restrictive option because it maintains the person's decision making ability. They're going to have the assistance of people that they've asked, that they've appointed, family members, friends, professionals. They can appoint whom they want to help them make decisions and to be able to focus their decision making and weigh their options. So this is definitely something to consider and to talk about with your family, with the professionals, caseworkers that are working with you. For folks that are receiving a form of income, whether it's SSI or SSD, you can have somebody appointed to be the representative payee. So that is something that the person can do. Again, as long, if guardianship has not been granted, that person can revoke the representative pay. They can change it. They do have that ability. When Social Security is looking to appoint somebody and get somebody involved, they well look to family and friends. If no options, then they do look to qualified organizations that are working with the person to be the representative payee. Social Security can require the person to complete an annual report. There are folks that are exempt from those reporting requirements. The natural or adoptive parents, legal guardian, spouse of beneficiary, folks like that are exempt from the annual reporting. Another form of helping in decision making is power of attorney. If the person is competent, they're able to understand what a power of attorney is, they can grant a power of attorney to somebody. And what I've done a lot of is I've done a lot of the durable power of attorneys, meaning that the person will get the power of attorney and it's in effect and it survives incapacity. So if something happens to the person at a later point in time and they become incapacitated, they're unable to make any decisions, the power of attorney survives, and the family member, the friend, whomever they've appointed as the attorney, in fact, can continue to act for them. So the power of attorney. So power of attorneys, they can be limited. They don't have to be general. I generally in these presentations tend to talk about a durable general power of attorney, but those power, in general means basically decisions in everything, financial, legal, etc. But you can do limited power of attorneys. You can limit it solely to financial. You can limit it solely to schooling, to legal. There are, and as well as healthcare too, which we'll talk about in just a minute. But so you can do limited power of attorneys as well. You can do general, limited, and they can be durable as well. One thing to point out: banks do have to accept them. I have had some issues with clients in the past where we've prepared it and the family member's taken to the bank won't honor it. I always make sure in my power of attorneys that I write to reference the statute that lays out that says the banks have to accept a valid power of attorney. For a power of attorney to be valid, it does have to be in writing. It does have to be notarized, and witnesses do have, you have to have witnesses to the signature at the time that it is put into effect. One of the things that you can also do, a power of attorney can have multiple attorneys. In fact, and you can have those multiple attorneys act severally. I don't know. I've always been of the opinion that having multiple attorneys, in fact, is not necessarily a good idea. But there could be situations in which it is necessary. But I just do like to mention that is an option, because sometimes people do ask that, especially if I'm working with a young adult who has two parents involved in their life, they both want to be able to make decisions or do something and not, parents will work with one another, but they want to have that ability. And so it is something that has come up. A power of attorney. So a power of attorney is, so what I sometimes will tell folks, if the person is competent, they can grant a power of attorney. You don't need to do guardianship, because it gives that person pretty much the general durable power of attorney will give the person a lot of the same abilities that you would have if you were guardian. But the good thing about a power of attorney is it can be revoked at any time. All the person has to do to revoke it: in writing, notarized, certified mail. Well, a little bit more tricky than that. As far as revoking it for the person, you just you get it, you write it out that you're revoking the power of attorney, you get it notarized, you send it regular and certified mail to your attorney. In fact, the only other catch is if you know that the power of attorney is on file somewhere, then you have to send that revocation letter, that notice, to any place that may have it on file. That's the only other catch. The best example is the bank. If a bank is still honoring a power of attorney, they won't get in trouble because they're acting in good faith until they receive in writing that it's been revoked. So you just want to, so if you do give somebody a power of attorney, just be in close contact with the attorney. In fact, know where it is on record. So if you do ever have to revoke it, it is something that can be done quite easily. When it comes to healthcare, we have advanced directives and healthcare proxies. So I do see, I think a couple more questions have popped up. It's, I have, I think, 13, 14 more minutes. I'm gonna run through the guardianship stuff, and then I'll come back to the question and answers, and I'll do them at the end. I'll go through the guardianship pretty quickly. So when it comes to healthcare, there are two types of forms we'd be looking at: an advanced directive and a healthcare proxy. An advance directive, also known as a instruction directive or a living will. It is used to tell a physician and family about the kinds of situations you would want or would not want to have life-sustaining treatment in the event you are unable to make your own healthcare decisions. The ones that I've written, it's, if you are not able to make decisions, you would not want an experimental treatment designed to prolong your life. Yeah, so there are ways that you can write it, but this is basically the advance directive. You're letting the hospital, the doctors, and your family know that there are situations in which you don't want them to artificially extend your life. The healthcare proxy, also known as a durable power of attorney for healthcare. This appoints a person to make healthcare decisions for you in the event you become unable to make them yourself. While you are, so unlike a regular general power of attorney, general power of attorney will go into effect immediately. A durable power of attorney for healthcare, it only goes into effect when the person becomes incapacitated. While they are, while a person is competent, no one else can or should be making decisions for them. That's again where you want that supportive decision making in place to help them make the right decisions in terms of their healthcare. If you do have a power of attorney for healthcare, you should make sure that it's on file with your doctor, treating hospital, nursing home. Make sure family members have it. This way, if something happens, people are going to know who to turn to in a time of crisis. So now we're going to talk about guardianship. Like I said, now we're at the most restrictive option when it comes to it's kind of, I say supported decision making, but at this point it's not supported decision making, because with guardianship you've taken away the person's ability to make decisions. One thing I actually, before I even get started on this, this has come up a couple of times with me because I do the special education work a lot. I did have a family member very, very, very recently, just this past week, asked me for some help in a special ed matter. And when we were making arrangements to get the records, the parent said, "Oh, and by the way, how do I get guardianship?" And I said, "What do you mean?" And the parent said, "Well, the school told me that if I don't get guardianship, I'm gonna lose my child. I'm not gonna be able to do anything in terms of the school." Like it was, and I said, No. I said, the school, nobody should be telling you to go and get guardianship. That is a decision that you and your family make together, whether or not that's something that needs to be done. That's not something that the school should be telling you. So whether or not you as a family member are going to attempt to get guardianship over another family member, that is a very personal decision, and is a decision that a family makes, and they make it if it's the right decision for their family. So there's different types of guardianship. There is limited guardianship, just like with limited power of attorney, where the person may only need assistance in certain areas. The one I'm going to talk a little bit about more is the general guardianship, the most restrictive of the guardianship, and that applies to a person who cannot make any decision. Once you get that plenary, that general guardianship, the legal guardian makes all decisions. As far as generally, in order to be able to get a general guardianship, the person does have to be incapacitated. If you look to the statute, it just means that they lack sufficient capacity to govern themselves and manage their affairs. It should only really be necessary for an individual who just cannot make decisions in pretty much in any area. Many individuals are capable of making their own decisions with appropriate support and advice, and do not need a guardian. A thorough assessment should be made of the individual to determine what, if any, capacity he or she has in making decisions in certain areas. When I have approached guardianship matters, and I've done a few of them, I always start with the doctors. I want to make sure that let me back up 1 second. If you, as a family, if you do decide to do guardianship, one thing to keep in mind is consider adding a co-guardian. A lot of times I've talked about this more with parents as they get older. If you get guardianship and you pass away, you cannot pass guardianship on through a will. The guardianship ends. So sometimes, especially if, and I hope this doesn't sound insensitive, if the family I'm working with, if the parents are older, sometimes we do talk about having a sibling or somebody else who is younger being added as a co-guardian to plan for the inevitable. So I'm sorry. So when you're looking to do guardianship, basically what you do need, there are documents that you need, And part of what you need are you need affidavits or certifications from 2 doctors that kind of lay out the need for guardianship. So what I always do before even deciding, I always meet with the family, talk about it, see if other options are available. If I can do a power of attorney instead, if I feel the person understands what a power of attorney is, that's the route that I'm going to go. If guardianship is necessary, I turn to the person's doctors. While it doesn't have to be a treating physician that does the affidavits to support guardianship, I prefer to see that because I want to make sure that this isn't a one-off doctor, that it is somebody that does know the person well enough so that I know that this, that this is something that does need to be done. I'm not going to go too much through this. This is more geared towards attorneys, I think, as far as the details of what needs to be filed and things like that. Again, if you do want this information, email me and I will certainly get it over to you. And this just talks about the supporting affidavits and certifications. And this is more for legal training that I've done. Back in May, they updated the court rules where there does have to be an affidavit or certification setting forth criminal and civil judgment history of each proposed guardian. But that can be waived if it's if the guardian is a parent, if the proposed guardian is a parent or married to the person. So you get all your pleadings together, you file with the court. The court will set it down for a hearing date. Basically, the court will send the proposed guardian a whole packet of information laying out what guardianship is, what their responsibilities are, their responsibility to visit, make recommendations, file reports with the court. And then there's different steps to take before, before the guardianship hearing. And then at the hearing, the court, I'm sorry, let me back up a second. The alleged incapacitated person does get an attorney of their own. If the family is low income or if the person is a recipient of DDD services, you can usually get a court-appointed attorney pro bono. They'll prepare a report in regards to whether or not they support guardianship in the matter and whether or not they support the proposed guardian. So the court will review that. There could be testimony if nobody objects to it and the attorney for the alleged incapacitated person doesn't object, the court can decide it on the papers. And then they'll issue the letters of guardianship. That's pretty much everything I wanted to talk about. Like I said, I could go into more detail, but it's more of the guardianship stuff is more of a how-to if you were going to do it. So I'm going to go to the question and answers. Just move this. So again, if anybody would like a copy of the slide presentation or has any questions or thinks they or a family member or somebody they work with, a client, could use services from the Community Health Law Project. Again, my name is Sean Benoit. That is my email address. My office phone number is there. Please don't ever hesitate to reach out. And again, if anybody wants a copy of the slides, please feel free to reach out. Okay, let's see some questions here. Is it appropriate for a district to cut related services if the student is in transition and has not matched goals in the service area? The reason provided is that they are aging out of school and in work program. No, the answer is no, it's not appropriate. And I touched upon that a little bit. They can still continue to receive related services. I mean, it depends. I tend to use OT, PT, and speech as one of the examples more so of the related services. If there are goals laid out in speech therapy and the person is not meeting them and they're 18 and they're going into, or 19, absolutely, they can still get those services. Merely aging out and going into a work program would not prevent that. Because, if the student's still having speech issues or in need of occupational physical therapy, once they do officially age out, after 21 or 22 now with the COVID extension, those are services that they can get through, that they could possibly get through DDD or Medicaid moving forward. Let's see, next question. Are the services...
Sean, we're going to need to wrap up with the questions so people can get over to the keynote.
Oh, okay. Okay. You know what? For the person asking, Sandra Villas, for that person, why don't you, my email address is there. Why don't you email me and I can kind of give you a little bit more on that. All right. Well, that is my presentation. Again, my email address. Please don't hesitate to reach out. And thank you very much, everyone, for being here today and for listening to me speak.
Awesome. Thank you, Sean. I appreciate it.
All righty. Thank you. Stay safe, everyone.